say doctor, Beatrice Onika Žarka. So she has an impressive curriculum vitae. She established basically, I understand, 2 lawyers' offices. And now she's leading under her own name and associates. And Mr. Daniel Stieger is the colleague, working together with Beatrice. I see you, Beatrice, you have experience also in court. I mean, at the other side of the table. And as you told me, because I said you wrote a book, so I was wrong, you wrote several books, I suppose, about law.
Some books. You?
Children books, about the topic of your profession.
Yes, of course.
Yeah. Then I see that Daniel, he is your partner in the business, and you have also a little bit shorter experience than Beatrice, but still quite impressive. Eh? Maybe you want to add something to that, Daniel?
Yeah, I'm a lawyer with approximately 14 years of experience, and my main area of practice is the one of the public procurement, of course. Here I offer assistance to our clients in every aspect of this field, including any litigation there is. And also I'm a contributor with the public procurement official gazette in Romania, where I wrote some numbers of articles in relation to specific issues that I met in practice.
Okay, thank you. I think it's time to begin for those that joined a little bit later. Alain Scott was not able to attend, so as president of the association, or as of the Chamber of Commerce, I will take the honors to be your host together with Elena. So, Beatrice and Daniel, the floor is yours.
Thank you.
Thank you very much, Kun. We are very happy to welcome you together with Baroc to our webinar. As already announced on the chat, as we moved in new offices, so we have a new brand, a new office, and with the same team, almost the same team. And we'd like to consider for the next seminar, we would organize it with Baroc to have it in our offices, which is in a very beautiful building dating 1900, and it's a place with a lot of good energy, which inspire us to organize also the webinar with the topic Public Procurement, an EU lesson to be learned. We will see whether the lesson was learned or whether there is a lesson in the documentation adopted by the European Commission and in the Romanian legislation, which was changed really recently with a great impact on the public procurement. I would like to ask Elena to ensure that Daniel can share our presentation. So
I'm already have the rights. Sure, I will share it now.
Excellent. So I would like Daniel to have the public procurement and EU lesson to be learned presentation already posted. As announced, the subject matter of this webinar concerns actually the adoption of Emergency Government Ordinance number 25 in April 2021, which amends and supplements some normative acts in the field of public procurement. This is the name, the title of the new legislation, which comes as a very interesting approach that our government took it on a matter which was the concern of the European Union for, which has been the concern of the European Union for some time. The story of the ordinance came to our attention by being preceded of the court decisions ruled by the Romanian Court of Appeals in the beginning of 2021. We are entrusted by a client to review two decisions ruled by the Romanian Court of Appeal, different panels in relation to a certain public procurement procedure on different lots, which our client won at that moment. Among other complaints made against the winning bid of our client, a particular one has drawn our attention, and it read like this. The Romanian Competent Jurisdictional Administrative Authority, which acts as a first floor court when a challenge is brought against the result of a procurement procedure, rejected without any grounds the complaints regarding the legal requirements applicable to the offers lodged by the economic operators from the third countries outside the EU. Well, what is very interesting is that in support of this claim, the plaintiff in both court procedures invoked on one hand the provisions of the European Commission's communication entitled Guidance on the Participation of Third Country Bidders and Goods in the EU Procurement Market, which was adopted in 2019. And on the other hand, a document, a very interesting document, white paper on leveling the playing field as regards foreign subsidies, issued on 17 June 2020, which was open to public consultation until 21st September 2020. We'll refer to this white paper, which is actually the source of the subject matter today. In relationship to the second document, it was stated that although the current legal framework regarding the public procurement field does not specifically provide a sanction for distortion in EU public procurement markets caused by foreign subsidies, the Romanian Contracting Authority has a wide margin of appreciation in analyzing the offers submitted in the public procurement procedures. Therefore, despite of non-existing sanction, the European Commission pointed out to the contracting authority in relation to the due diligence that they must show in the analysis of the offers. What is even more interesting in relationship to this allegation is that being raised the same allegation in front of the same court, but in front of different panels, the same court in the two different panels ruled completely opposite solutions. What's even, one decision stated that such allegation has merits, and thus it is imperative that the contracting authority shall proceed with the re-evaluation of our client's offer in order to assess whether or not there is a distortion that might arise from the said offer, while the other decision rejected totally the allegation, considered that those allegations do not have any kind of merits, and consider that on one hand, that the European Commission interpretative communication on the participation of third country bidders and goods in the EU procurement market does not actually regulate any new ground on which the offer of such operators can be dismissed, providing only certain recommendations regarding the analysis of such offers. And in addition, in order to the court to oblige the contracting authority to proceed with the evaluation of the offers, such as the one of our client, the plaintiff should have provided concrete, clear evidence that some offers had an abnormally low price, or that some tenders are receiving subsidies or would engage in dumping or in other unfair activities or fail to fulfill their environmental or labor obligations. So it is amazing to see how the practice of the court was divided while considering the same two documents. But certainly this approach gave a lot of food to think to the contracting authorities. That's why, in order to have a complete picture of this particular situation, we have made a thorough analysis of the white paper on the leveling the playing field as regards foreign subsidies. Analysis which will reveal several interesting aspects which will be presented further. While the analysis was pending, the government adopted in April the governmental emergency ordinance number 25, in which, in a legislative effort to apply Article 25 from the Directive 24, modified completely the notion of the economical operator, allowed to participate in public procurement, to limit this notion only to those entities coming from EU and for countries with which EU has agreements of certain types. Basically, the governmental emergency ordinance sorry, provides expressly that the entities coming from four countries which did not conclude agreements with the EU shall be excluded from the procedure without the need for verifying and further compliance. Sorry. As this legislation and the practice of the court impact strongly on the public procurement, we consider that the subject matter is of actual great interest to be debated in the webinar. And I will give the floor now to my colleague to introduce you in the analysis of the white paper.
Okay, thank you. Okay. I will begin by pointing out that the first thing to be noted about this white paper is that it was prepared with the intention to launch a broad discussion with member states, other European institutions, all stakeholders, including industry, social partners, civil society organizations, researchers, the public in general, and any other interested party on the best way to effectively address the challenges identified in it. Following that, the results of the consultation on this white paper to prepare actually the ground floor for choosing the most appropriate way to address the distortion created by foreign subsidies in appropriate proposal for legal instruments. In terms of how it is structured, this document first outlines the rationale for addressing foreign subsidies, including typical examples of foreign subsidies that appear to undermine the level playing field in the internal market, then presents an analysis of the existing legal instruments to address foreign subsidies and discusses the question of a regulatory gap. Subsequently, it sets out preliminary substantive and procedural orientation for legal instruments to address the regulatory gap in relation to, on one side, foreign subsidies distorting the internal market regarding the general market operation of economic operators active in the EU, acquisition of EU undertakings, and public procurement procedures. In addition to the foreign subsidy matter, with regard to these specific procedures, the white paper emphasized the need to uniform the observance of the environmental standards, labor and social protection. Also, on the other hand, the white paper addresses the subject of foreign subsidies in context of access of EU funding. This being said, before proceeding further, we must provide the definition of the term foreign subsidies, as this is the main subject matter of the white paper and which will be used extensively further on. So according to the definition detailed in Annex 1 to the white paper, a foreign subsidy refers to a financial contribution by a government or any public body of a non-EU state which confers a benefit to a recipient and which is limited in law or in fact to an individual undertaking or industry or to a group of undertakings or industries. In connection with this definition, the white paper states also that a private body entrusted with functions normally vested in the government or directed by the non-EU government can also grant a foreign subsidy. The recipient mentioned in the definition may be an undertaking established in the EU or in a third country. The definition covers foreign subsidies granted directly to undertakings established in the EU, foreign subsidies granted to an undertaking established in a third country where such subsidy is used by a related party established in the EU, and foreign subsidies granted to an undertaking established in a third country where such a subsidy is used to facilitate an acquisition of an EU undertaking or participate in public procurement. An important note must be made here that according to those mentioned in the white paper, it is presumed that foreign subsidies below a threshold of 200,000 euros to an undertaking over a period of 3 years do not create distortions in the internal market. So, in view of this and of the analysis made in the gap analysis chapter, which we will not be presenting because it's in own, can be dedicated with a webinar, the white paper concluded that the issue granted by the distortion caused by the foreign subsidies on the internal market so far has not been exhaustively addressed by any of the existing legal instruments. Consequently, in view of this, the white paper proposes solutions and, as stated by the Commission, calls for new tools to address this regulatory gap. In this context, 3 options, so-called modules, are put forward aiming at addressing the distortive effects caused by the foreign subsidies in the single market in general, Module 1, in acquisition of EU companies, Module 2, and 3, during EU public procurement procedure, Module 3. It is mentioned that these modules may be complementary to each other rather than alternatives. The white paper also sets out a general approach to foreign subsidies in the context of the EU fund, but we will not address this aspect in this webinar. In brief, Module 1, entitled General Instrument to Capture Distortive Effects of Foreign Subsidies, proposes the establishment of a general market scrutiny instrument to capture all possible market situations in which foreign subsidies may cause distortion in the single market. Under this module, the supervisory authority, which would be a national authority or the Commission, could act upon any indication or information that a company in the EU benefits from a foreign subsidy and start an investigation. If the existence of a foreign subsidy is established, then the authority would impose measures to remedy the likely distortive impact, such as redressive payments and structural or behavioral remedies. However, it could also consider that the subsidized activities or investment has a positive impact which outweighs the distortion and thus not pursue the investigation further. The second module, entitled Foreign Subsidies Facilitating the Acquisition of EU Companies, aims at ensuring that foreign subsidies do not confer an unfair benefit of their recipients when acquiring stakes in EU companies, either directly by linking a subsidy to a given acquisition or indirectly by the de facto increasing the financial strength of the acquirer. Under Module 2, companies benefiting from financial support of a non-EU government would need to notify their acquisition of EU companies above a given threshold to the competent supervisory authority. It is proposed that the Commission should be the competent supervisory authority. Transaction could not be closed while the Commission's review is pending. Should the supervisory authority find that the acquisition is facilitated by the foreign subsidy and distorts the single market, it could either accept commitments by the notifying party that effectively remedy the distortion, or as a last resort, it could prohibit the acquisition. Under this module, the Commission could also apply the EU interest test proposed in Module 1. Module 3. This is the module which basically is the main topic of this webinar, being the specific one based on which it appears that the Romanian legislation in the public procurement field was recently amended through the Emergency Ordinance 25 presented before by my colleague. Before diving into the actual presentation of this Module 3, there are certain aspects to be mentioned which from the Commission standpoint represents a regulatory gap in the field of public procurement at this time, which may lead to distortion to the EU procurement markets due to foreign subsidies. This is due to the fact that currently the EU legislation in this field does not contain specific regulation that address such distortion. As single market instruments, the EU public procurement directives does not set out specific rules regarding the participation of economic operator benefiting from foreign subsidies. More currently, the contracting authority enjoy a wide margin of discretion, both in the design of a public tender procedure, as well as in the evaluation of the tender submitted in the procedure. In addition to that, they are legally required to investigate the existence of foreign subsidies when evaluating offers, and even if a distortion may be found due to the existence of foreign subsidies, there is no specific legal consequences to take effect in such a case. The EU committed itself under several international agreements, such as the Agreement on the Government Procurement and bilateral free trade agreements with procurement chapters, to grant access to its public procurement market to the goods, services, and suppliers of several third countries. Accordingly, the Public Procurement Directive provides for public buyers in the EU the obligation to grant the works, supply, services, and economic operators of the signatories to those agreements a treatment that is no less favorable than the treatment which the works, supply, services, and economic operator of the EU enjoys as long as the public procurement in question is covered by these agreements. Beyond that obligation, based on those mentioned in the communication of the European Commission entitled Guidance on the Participation of Third Countries Bidders and Goods in the EU economic operators from third countries which have not entered into any agreement with the EU providing for the opening of their public procurement market, or whose goods, services, or works do not have secured access to procurement procedures in the EU, may be excluded. In practice, decisions to exclude third country bidders without secured access could be justified by the recipient of foreign subsidies, but in the current legal framework, there is no such link. In the current existing legal framework, both European and Romanian, public buyers may consider the existence of foreign subsidies when evaluating risk in terms of contract performance and execution. More specifically, public buyers may consider the reliance on subsidies when assessing the overall financial viability of an offer. For this assessment, Article 69 of Directive 24 from 2014 on public procurement provides the contracting authorities with the possibility to reject offers they consider to be abnormally low in situation where the explanations and evidence supplied by the bidder do not sufficiently account for the low price offered. Where as part of that assessment, it can be established that a bidder has obtained EU state aid incompatible with the Treaty on the Functioning of the European Union, enabling to make a low offer. The tender may, under additional conditions, be rejected on that ground alone. In contrast, Article 69 of the Directive contains no corresponding provisions for foreign subsidies that enable bidders to submit low offers. If the grant of foreign subsidies can be considered in the overall assessment and the public buyers ultimately decide to reject an offer as abnormally low, such a rejection needs to be justified by demonstrating that the foreign subsidies impede the viability of the offer and the bidder's capacity to execute the contract at the abnormally low price offered. Basically, the situation is similar for the Romanian public procurement procedure. Based on Article 210, paragraph 4 and 5 of Law 98 from 2016 on public procurement, the contracting authority has always the obligation to reject those offers which are deemed to have an abnormally low price due to non-observance of certain legal obligation, and also can reject a specific offer who received a state aid, which is the reason of the low price offered, only if the respective tenderer was not able to demonstrate that the state aid has been legally granted. If rejects an offer based on the latter situation, the contracting authority has the obligation to inform the EU Commission after consultation with the Romanian Competition Council. Another aspect envisaged by the white paper as a possible measure to counteract the distortion due to foreign subsidies is the fact that public buyers in the EU are also encouraged to require high environmental and social standards in their procurement and to ensure that EU and third country bidders are held to the same standards. In fact, the technical specification, exclusion selection, and the work criteria, as well as defined contract performance clauses that ensure the respect of high standards. But while such requirements might in practice help creating a level playing field, it is admitted that they are not designed to address the potential distorting effect of foreign subsidies in general, and even less for subsidized entities established in the EU, as those are already to the same subject to the same rules as their non-subsidized peers. In practice, public buyers do not have the information necessary to investigate whether bidders benefit from foreign subsidies or to assess to what extent the subsidies have the effect of causing distortions in the public procurement markets. Public buyers may also have a short-term economic incentive to award contracts to such bidders, even if the low price offered result from the existence of foreign subsidies. It appears that currently there are discussions held in the Council in relation to a regulation on the access of third countries' goods and services to the Union's internal market in public procurement and procedures supporting negotiation on access of Union goods and services to the public procurement markets of third countries. In the form that was prepared latest in January 29th, 2016. The main objective of this regulation, also known as the International Procurement Instrument, or EP, is to incentivize the trading partners to negotiate to the EU the opening of their procurement markets for EU businesses. Provided that the EP will be adopted in its current form, it aims at improving access to public procurement markets outside the EU. But even this piece of legislation appears not to tackle distortions of the procurement process in the internal market arising from foreign subsidies granted to undertakings participating in the EU procurement markets. As an overall conclusion, it appears that the existing rules in the field of the EU public procurement are not sufficient at this time to address and remedy the distortions caused by foreign subsidies. Hence, where foreign subsidies facilitate and distort the bidding in an EU public procurement procedure, there appears to be a regulatory gap. As the actual analysis of the module 3, this is made in several distinctive parts. So first is the introduction. In view of the gap I've just explained, the white paper proposes and dedicates an entire special module, this module 3, which is intended to implement an appropriate legal instrument and which ensures that foreign subsidies can be addressed in individual public procurement procedures. EU public buyers would be required to exclude from public procurement procedures those economic operators that have received distortive foreign subsidies. This new ground for exclusion could apply both to the procedure in question, but may also lead to the exclusion from subsequent procurement procedures, provided that certain conditions are met. The scope of this ground for exclusion will be defined in the light of the EU's international obligation under the WTO Government Procurement Agreement, or GPA, and various bilateral agreements providing for access to the EU procurement market. The second aspect in the white paper refers to the distortion by foreign subsidies in the context of the public procurement procedures. In relation to this, it is stated that the absence or presence of the effect of the foreign subsidy will be assessed in relation to a specific procurement procedure. It is necessary to determine whether the foreign subsidy facilitates the participation in the public procurement procedure, namely whether it enables the economic operator benefiting from the subsidy to participate in the procedure, to the detriment of unsubsidized undertakings. Thus, foreign subsidies in procurement may give rise to a distortion of the procurement procedure either directly by explicitly making a link between the subsidy and the given procurement project, or indirectly by the default increasing the financial strength of the recipient, where this enables the recipient to submit an offer that would otherwise, without the subsidy, be economically less sustainable, especially in case of bidding significantly below market price or below cost. A distortion may be presumed. In other cases, the distortion may be examined according to the principles and criteria that are outlined in section 413 of the white paper, which themselves are also worth an entire webinar. So we will not touch this subject in this one. To the extent they are relevant and capable of demonstrating the foreign subsidy facilitates the participation in the public procurement procedure. As a side note, in order to ensure an uniform practice of assessment of distortion by the contracting authority, a uniform methodology or guidance to the contracting authorities will be necessary to be properly envisaged. As regards aspects. Okay, sorry, my bad, it was fine. Okay, as regards the aspects related to the actual procedure envisaged by the white paper, in relation to the initiation of the actual procedure, it is proposed that the economic operators participating in public procurement procedures will notify to the contracting authority when submitting their bid whether they, including any of their consortium members or subcontractors and suppliers, have received the financial contribution within the meaning of the definition we have provided within the last 3 years preceding the participation in the procedure and whether such a financial contribution is expected to be received during the execution of the contract. Moreover, the white paper proposes thresholds and additional conditions for notification, which could be introduced in order to address only those foreign subsidies in public procurement that might cause distortion of the procurement procedure and to limit the administrative burden for public buyers and the competent supervisory authorities, namely, the relevant subsidy period could be limited, for example, to a period of 3 calendar years prior to the date of the notification and including the year following the expected completion of the contract. Notification could be required only above a certain foreign financial contribution value, and a threshold could be defined that is higher than the threshold for the application of the public procurement directives. As regards the notification, it is provided that it should contain the necessary information to assess whether the economic operator benefits from foreign subsidies in the procurement procedure. A complete notification will have to contain at least the following elements: legal information, including ownership and governance of the tenderer, any consortium member, and those subcontractors and suppliers having received foreign financial contribution, main sources of overall financing of the tender, total amount of foreign financial contribution received in the past 3 years, foreign financial contribution received specifically for the purpose of participation in the respective public procurement procedure, or foreign financial contribution that will be received during the expected execution of the contract. Having examined the completeness of the notification, the contracting authority would transmit the notification to the competent supervisory authority to investigate the information and assess the existence of a foreign subsidy. For transparency reasons, the notification would be published. Also, failure to comply with the notification obligation could be sanctioned by the contracting authority with significant fines and, in extremis, an exclusion from the procurement procedure or termination of an ongoing contract. It is also stressed that a prior notification obligation in case of subsidy participation in public procurement procedures would require a degree of self-assessment by economic operators. They will need to determine to what extent they are beneficiary of foreign financial contribution in order to ascertain whether there is a requirement to notify the submission of the bid, which involves a financial contribution. Such a self-assessment carries a significant risk of error and deliberate circumvention by economic operator, as they may not be aware of the existence of a financial contribution, or even unwilling to disclose their existence to the contracting authorities. Third parties and competitors are therefore entitled to inform the contracting authorities that a notification should have been made in the procedure. These submissions have to be sustained and provide prima facie evidence for the necessity of notification. Investigation by the competent supervisory authority and interplay with the ongoing procurement procedure. It is suggested in the white paper that both the Commission and the national authorities are granted powers and that the system also provides for coordination in order to ensure coherence. Cooperation between the Commission and the national supervisory authorities could work similarly to the existing cooperation in antitrust pursuant to Regulation 1 from 2003. So the actual procedure proposed by the white paper is this. The contracting authority transmits the notification to the competent supervisory authority at member state level to investigate the information and assess the existence of a foreign subsidy. It may also alert the national supervisory authority in situation where it has sufficient plausible indications that a tenderer received the foreign subsidy which it did not notify. The investigation will be in 2 steps, with a preliminary review and an in-depth investigation. In a preliminary review, the National Supervisory Authority will seek to obtain the necessary information about the existence of a foreign subsidy and the condition upon which it has been granted. If in the context of the preliminary review, the National Supervisory authority concludes that no foreign subsidy exists, it informs the contracting authority of this conclusion, and it does not intend to start an in-depth investigation. If, however, the national supervisory authority concludes in the preliminary review phase that a foreign subsidy may exist, it opens an in-depth investigation to confirm the existence of a foreign subsidy. In both cases, the national supervisory authority informs the Commission, the contracting authority, as well as the competent supervisory authorities of the other member states thereof through a summary on a notice. At the end of the in-depth procedure, the national supervisory authority can either arrive to the conclusion that there is no foreign subsidy in the procurement procedure, or it can decide that a foreign subsidy exists. However, in both cases, and prior to communicating this conclusion to the contracting authority, the national supervisory authority informs the Commission on a draft decision, thus ensuring that the national authority's decision is reached in close cooperation with the Commission. The review has to ensure that public procurement procedures are delayed as little as possible. Therefore, strict time limits would be introduced, such as a maximum of 15 working days for the preliminary review by the National Supervisory Authority, and no more than 3 months for an in-depth review. If the Commission, when informed of the final decision, disagrees with the assessment of the National Supervisory Authority, the deadline for the in-depth review will be extended. During the investigation, the contracting authority is barred from awarding the contract to the investigated economic operator. Nevertheless, such suspension can be lifted under specific, clearly defined circumstances, which could be linked in particular to situation of urgency or to financial risk linked to necessary funding for a project. It is proposed that guidelines could be issued detailing clear rules for lifting the suspension. Otherwise, the procurement procedure is pursued. This has the following consequences. Upon notification and its transmission to the competent supervisory authority, the contracting authority should pursue the evaluation of the offers. It can establish the economic operator to whom the contract would be awarded on the basis of the evaluation, not taking into account a possible distorting foreign subsidy. Should this economic operator not be an economic operator under investigation, the contracting authority can award the contract and conclude the procurement procedure. In this case, it informs the competent supervisory authority. Should the economic operator to whom the contract is to be awarded be an economic operator under investigation, the procurement procedure will have to be suspended until the competent supervisory authority has concluded its review of the foreign subsidy and transmitted its opinion to the contracting authority. As regards the redressive measures, if the supervisory authority in its review confirms that the economic operator has received the foreign subsidy, the contracting authority would determine whether that subsidy has distorted the public procurement procedure. If so, it will exclude this economic operator from the ongoing procurement procedure. It may also be envisaged to introduce an exclusion of such economic operator from future procurement procedure for a maximum of 3 years. During that period, the economic operator will have the opportunity to demonstrate that it no longer benefits from a distortive foreign subsidy when participating in a public procurement procedure, and in this case, it can participate in future procurement procedure. More specifically, if the supervisory authority reaches the conclusion that there is no foreign subsidy in the procurement procedure, it will communicate this conclusion to the contracting authority by decision. In this case, the economic operator concerned will not be excluded from the public procurement procedure by the contracting authority unless the contracting authority finds another ground for exclusion different from the existence of a distortive foreign subsidy under the EU public procurement legislation. On the other hand, if the supervisory authority reaches the conclusion that there is a foreign subsidy, it will communicate this conclusion to the contracting authority, which then determines, on the basis of a uniform methodology, which could be set out in guidance designed to ensure a uniform practice of assessment of distortion throughout the EU, whether that subsidy has distorted the public procurement, and if so, imposes redressive measures on the subsidized operator. The redressive measures for procurement procedures consists of the exclusion of the subsidized bidder from the ongoing public procurement procedure, and potentially also the exclusion of the subsidized bidder from future public procurement procedures before that authority for a certain time. This kind of a decision will be subject to remedies. The white paper also assesses certain aspects related to foreign subsidies in public procurement pursuant to intergovernmental agreements. In this respect, it is stated that certain procurements, especially for large infrastructure projects, might be organized under intergovernmental agreements with countries that are not subject to the EU procurement regime. Tender procedures under such agreements are exempted from EU public procurement legislation under the condition laid down in Article 9 of Directive 24 of 2014 and Article 20 of Directive 25 from the same year. The intergovernmental agreement must be intended for the joint implementation or exploitation of a project by their signatories, and the procurement regime of the agreement has to be compatible with the EU treaty. As for procurements covered by the procurement directives, there is no specific scrutiny of foreign subsidies and their distortive effects on the procurement under such agreement. To ensure a level playing field, also for procurement under such agreements, it is advisable to apply the suggested approach also to procurements under those agreements. Due to the specific nature of such agreements, the competent supervisory authority in this case should be only the Commission. Finally, after the public consultation ended on 23rd of September 2020, a summary of the responses was released by the Commission. In brief, as regards those proposed by the white paper in Module 3, the feedback was that the majority of member states who replied agree with legal action in area of public procurement, but not necessarily with the proposed framework of Module 3. These member states consider that the white paper rightly identifies the problem, risk associated with the participation in public procurement procedure by subsidized bidders, and agree broadly with the gap analysis. Several member states are opposed or skeptical about the need of a dedicated legal instrument to tackle the distortive effects of foreign subsidies in public procurements. Some of these member states disagree with the premise in the white paper that foreign subsidies have a negative effect on public procurements. Others consider that the issue could be addressed, or at least partially addressed, by existing rules on abnormally low tenders in the public procurement directives, either by issuing guidance on existing rules or by a modification of these rules and integrating some of the features detailed in Module 3, for example, notification obligation, review procedure, adding an exclusion ground. The majority of member states expressed their concern about the proposals in the white paper on the sharing of responsibilities between contracting authorities and supervisory authorities with regard to the assessment of distortions caused by foreign subsidies. For certain reasons, member states broadly agree that contracting authorities should not be responsible for assessing whether a foreign subsidy distorts the public procurement procedure, and that this task should instead be incumbent on the national supervisory authority or the Commission. Moreover, there were voices stating that the Commission should have exclusive powers for assessing whether a foreign subsidy is distortive in the interest of consistency and legal certainty. Other EU stakeholders basically had similar feedback as the member states, while the non-EU contributors in general do not specifically address public procurement. Now, last but not least, following all that we have detailed up to this point in our presentation, it is now time to present also the latest amendments that were made to the Romanian legislation in the public procurement field. We are referring here to the Emergency Government Ordinance number 25 from 31st March 2021, amending and supplementing some normative acts in the field of public procurement, which was published in the official Gazette No. 346 from 5th of April 2021. According to this piece of legislation, some of the reasons which led to its issuance, as stated in its introductory part, were the following, and I quote: "The objective state of affairs of the extraordinary situation is determined by the fact that this normative act aims to modify the legal framework in the field of public procurement so as to redefine certain general rules for participation in award procedures in accordance with Article 25 of Directive 24 from 2014, which establishes the obligation of member states to ensure equal treatment with that offered to economic operators in the states of the European Union only for economic operators in the signatory states of the agreements referred to in this text of law. The state of affair, independent of the government's will of the extraordinary circumstance, is determined by the situation in recent years in which there has been an increase in the number of bidders from outside the community in public procurement procedures, which offers a reduced guarantees of compliance, such as certified quality standards, environmental and sustainable development standards, requirements related to working condition and social protection, competitive policies. In this respect, the participation of non-EU third country operators in public procurement procedure, especially in the field of transport, as well as in other strategic areas, with an impact on the sustainable economic and social development of the country, can decisively endanger the large public investments in Romania. And also another interesting reason is that the quantifiable state of affair of the extraordinary situation is determined by the fact that in the field of rail and road transport, the award procedures will be initiated within major investment project financed from structural funds and investments related to the 2014-2020 programming period, and respectively 2021-2027 of the National Recovery and Resilience Plan and of the state budget, for which a level playing field between companies from EU member states and those outside the European space cannot be ensured, nor the uniform observance of environmental standards, labor and social protection, and sustainable development, a situation which is likely to generate blockages and delays in the conduct of award procedures. As it can be noticed, the Romanian legislator appears to have grounded the issuance of this decision on the provisions of Article 25 of Directive 24 from 2014, which states, and I quote exactly, "Insofar as they are covered by Annexes 2, 4, and 5, and the general notes to the European Union's Appendix 1 to the GPA, which is the World Trade Organization Agreement on Government Procurement, and by the other international agreements by which the Union is bound, contracting authorities shall accord to the works, supplies, services, and economic operators of the signatory to those agreements treatment no less favorable than the treatment accorded to the works, supplies, services, and economic operators of the Union." Furthermore, this normative act amends Law 98 from 2016 on the public procurement, Law 99 from 2016 on sectorial procurement, and Law number 100 from 2016 on works, concessions, and service concessions. No amendments whatsoever were made to any of the application methodological norms of any of said law, and also no amendment was made to Law number 101 from 2016 on remedies and appeals concerning the award procurement contracts. This being said, and given that basically the amendments are the same for all previous mentioned law, we will present them only by reference to Law 98. Here we have a comparative table in which we have presented the legal provisions subject to the amendment before and after. So the first amendment made by the ordinance is made to Article 3, paragraph 1, letter JJ, which stated previously, which provided previously the definition of the economic operator, which was any natural or legal person, public or private, or group or association of such person, which lawfully offers on the market execution of works and or a construction, the delivery of products on or the provision of services, including any temporary association formed between two or more of these entities. Now, the new word is the following. The economic operator is defined as any natural or legal person, public or private, or group or association of such person, including any temporary association formed between two or more of these entities, which lawfully offers the market execution of the works, the delivery of products on the provision of the service, and which are established in an EU member state, a member state of the European Economic Area, third countries which have ratified the World Trade Organization Agreement on Government Procurement, to the extent that the awarded public procurement contract falls under the scope of Annexes 1 to 4 and 5, 6, and 7 of the European Union's Appendix 1 to the respective agreement, third countries which are in the process of joining the European Union, and fifth, third countries not covered by point 3, but which are signatories to other international agreements by which the European Union is obliged to grant free market access in the field of public procurement. Moreover, another article which was amended was Article 49, which previously stated that contracting authorities have the obligation to grant economic operators an equal and non-discriminatory treatment and to act in a transparent and proportionate manner. Now, states, the contracting authorities have the obligation to grant economic operators an equal and non-discriminatory treatment and to act in a transparent and proportionate manner. The second paragraph states that to the extent that are covered by Annexes 1 to 4 and 5, 6 and 7 to Appendix 1 of the European Union to the GPA and other international agreements which impose obligation on the European Union, the contracting authority shall grant the works, products, services, and economic operators of the signatory to this agreement an equal treatment with the one granted to the works, products, services, and economic operators from the European Union. Article 53, paragraph 1, was stated that previously that any economic operator has the right to participate in the award procedure as tender or candidate, individually or jointly with other economic operators, including in temporary association forms established for the purpose of participation in the award procedure under the conditions provided by this law. Now it is stated that have the right to participate in the award procedures provided in Article 68 as individual bidder, associated bidder, candidate, supporting third party, subcontractor, the economic operators defined in Article 3, paragraph 1, letter JJ. A new paragraph was inserted in this Article 53, namely paragraph 1. Third party subcontractor, which does not fall within the definition from Article 3, paragraph 1, letter JJ, without the need to verify compliance with the provisions of Articles 164, 165, and 167. Those three articles provide the legal grounds for the exclusion of a bidder or candidate. Moreover, the decision provides that within 30 days as of its entry into force by joint order of the Ministry of Economy and the President of the National Agency of Public Procurement, the list of countries falling into the newly introduced categories shall be approved, following that this list to be updated annually or whenever necessary within 30 days as of the occurrence of any changing situation. As regards the awarding procedures in which the economic operators already submitted their offer on the date of the entry into force of this ordinance, it is stated that this will remain subject to the legislation in force at the date of their initiation. So, in conclusion, although at the European Union level there is not yet any piece of legislation issued or in force in connection with the aspects that the white paper envisages, the Romanian authorities adopted the ordinance invoking as EU legal framework grounds the transposition of Article 25 of Directive 2014 on public procurement, of Article 43 of Directive 25 from 2014. But it appears that actually this ordinance is just the implementation of the Romanian legislator's own particular interpretation of the invoked EU legislation, the latter merely stating that no less favorable treatment will be accorded to the work, supply services and economic operators of the third states which signed various international agreements with the EU, while the ordinance basically imposed for the contracting authorities the legal obligation to directly exclude any economic operator which does not fall under the new definition detailed in Article 3, paragraph 1, letter JJ, without the performance, for example, of any investigation or assessment whether an economic operator was granted with a foreign subsidy or is not able to guarantee a similar European standards in the area of labor, environment, and or social security. This seems at this time, at least, something of nature to be in a direct breach of at least two of the main EU principles, namely the non-discrimination and equal treatment. This being said, I will now get back to Mrs. Monica Jarca for the conclusions of this webinar. Thank you once again for attending and for your attention.
Thank you, Daniel. After this detailed presentation of the new Romanian legislation and the white paper and consequently the IC guidance in public procurement, I would consider that the conclusions of this presentation could be transformed in a Q&A, and I would invite you all to take part in this let's say conclusions drawing under the form of questions with answers. So I would invite you to consider answering to the questions which we posed on the in the presentation. It is obvious that the intent of the Romanian legislator was to support a little bit avant la lettre the European Union position to be regulated mandatory. As noted, the white paper and the EC guidance are only at the level of recommendation. Is it for you, from what you understood from the presentation my colleague made, is it that you understood that this ordinance number 25 actually applies the principles of white paper and the EC guidance? Can I engage you actively in answering to this question? No? Well, at the first sight, the Romanian legislator has said is trying to support the position of the European Union in the matter of public procurement. This is what actually the intent of the legislator was from the very beginning. Nevertheless, the Romanian legislator went a little bit farther from the principle of white paper and the IC guidance although the intent was good, I think that the modification of the government ordinance is going, brought by the government ordinance 25 is going to bring a lot of interpretation, as it was, it is a blunt application of the Article 25 from the Directive 24. To go further to the second question, does this ordinance exclude for the categories of bidders listed as now acceptable in EU public procurement the application of the white paper and the EC guidance? And my answer will be no, because it is obvious that the white paper and the IC guidance have more, let's say, elaborated conditions of compliance to be checked bidders, even though they would fall under the categories of the bidders which are accepted. And the last question, is the ordinance number 25 compatible with EU law? And it is a correct transposition of the Article 25 of the EU Directive 2014-24. Is it anybody who would like to engage in this, in answering to this question? No?
I think the volume of information is very great, so I understand the
Juana?
direction.
I saw that, okay. So I saw that one of my former students who is also a doctor in the, she holds a PhD in European Union law. She was a participant, but I think she will not be able to answer. Well, this is the most troubling questions to be answered, and it will raise a lot of discussions, both under national law and European law. My position is that the Romanian government, the Romanian legislator, took a blunt position on the matter of transposition of Article 25. Although Article 25 of the Directive 24 actually refers to the ensuring an equal treatment or the same favorable treatment for the entities coming from the countries with which European Union concluded a sort of agreement. It does not say that actually the others should be fully expelled from the public procurement procedure. So there will be probably many things to be discussed and debated in the following months based on this ordinance, and based on the compatibility of this ordinance with the European Union law and the correct transposition of the principles of European Union in the public procurement, as it is also the discrimination. So it is a very challenging piece of legislation. I consider that there is still legislation to come from the European Union. I mean, there are many hints that the white paper might transform in a regulation of the European Union. And then it will be very interesting to see how the Ordinance 25 will cope with the new regulation, which will mandatory regulate the compliance of the entities coming from the four countries to the European Union in the public procurement procedures. So if you have any questions, we'll be happy to be at your services.
Daniel and Beatrice, I want to thank you for to bring a very complex matter in a very structured way to the audience. As nobody had a question, I was wondering, we are talking about equal treatment, level playing field for this public procurement with non-EU states, but you know, we already have within the EU a huge difference in labor costs between countries. We have tax systems that are really different if you compare, for instance, Romania with the northern countries. So that is already a reason to say not easy to have a level playing field. And if you go then outside the EU, and let's just go to Ukraine. And Ukraine, there's a company that wants to be involved in public procurement in Romania. How can you correct for the differences in social legislation and social benefits? I don't think it's an easy question to answer, but then we only talk about Ukraine. You have these very low wage countries where you even have child labor. Let's be honest on that. How do you tackle that within this legislation?
I think that your concerns are very grounded, as are the concerns of the entire European Union. What is very important to understand is that the European legislator has to create useful instruments in order to actually make this non-discrimination principle applicable also from the point of view of the entities coming from countries as Ukraine, as you said earlier. So what we are saying is that it's not actually, let's say, simple to just cut out the participation of the entities coming from four countries which do not have agreements with European Union, but rather to create and educate the public procurement authorities to create instruments and educate the public procurement entities to apply these instruments and check on the compliance, also on the matters you just said it, on the matters of environmental law, social policy, labor, and of course state aid, state subsidies.
In addition, if I may complete the answer Mrs. Sonica Jalca said, reducing your question strictly to the public procurement procedures, it is basically somehow presumed that the EU member states, countries, and even that third countries which are in the process of joining the European Union are basically presumed that they are in line with all the regulations imposed in these fields by the European Union.
Okay. Now, a concrete example. I read that Mr. Orban, Orban from Orbanistan, Hungary, he decided to work with the Chinese to set up a huge university with public money, and will be built with Chinese labor and so on. Now, if you get that case on your plate and you are in a more democratic country like Romania, what would be the reaction of the authorities be?
It is clear that in this situation, Hungary doesn't have restrictive legislation in regards of expelling the entities coming from China, for example, from participation in public procurement. So this is what we have discussed earlier and we have presented earlier. This is why an instrument which is mandatory at the level of the European Union will be more helpful than the Romanian legislation did by adopting ordinance. At the European level, a regulation would come with a very clear criteria, which all the contracting authorities from all countries in Hungary